Yes, Miss Ford. I'm sorry to keep you waiting a bit.
Not at all. My lords, yesterday we were looking at the industry expert reports and at Mr. Robinson's first report.
Yes.
Which was produced before the CPO application was lodged, and so obviously before we had any idea what points the respondents might raise against us. We're now moving on to Mr. Robinson's second report, and this is where you see Mr. Robinson engaging with and responding to the points which are now being raised by the respondents, and to the extent appropriate, seeking to address or accommodate them. And my Lord Justice Snowden was asking me yesterday whether it was permissible at this stage for a class representative to say, well, I'm not going to engage with what's being said against me, I'm going to ignore it. In our submission, what we see in this report is that we are not ignoring what's being said, we're properly considering it and engaging with it. But of course, we're not obliged to agree with it. And what we see in the report is a distinction between two scenarios. The first is a scenario where the respondents have criticised Mr. Robinson's approach.
Is this tab 16?
My Lord, yes, in supplement
Volume
2.
Yeah.
In my submission, there are two types of scenarios that come out of this report. The first is one where you see the respondents have criticised his approach, but they haven't provided any concrete evidence which might cause him to depart from the clear evidence he's already seen from the industry experts on the basis of which he has expressed a view. And in those scenarios, he considers whether he needs to make any changes to his assumptions, and he concludes that he doesn't, but he expresses a willingness to do so if and to the extent that additional evidence is adduced which does cast doubt on the assumptions that he has made. And that's the first scenario. In my submission, that's a perfectly proper and sensible approach for him to be taking. The second scenario is where the respondents have raised a point which he does consider potentially necessitates further thought or analysis. And in those scenarios, he has addressed the respondent's case, including in particular suggesting an adjustment to reflect the evidence that he's been shown. To give you some examples, starting at 2.6 on page 416, there's a heading factual basis underpinning the assumptions upon which my proposed methodology is reliant. And what he's doing here is addressing a criticism from the MNW respondents and KK that there's an issue with his proposed methodology because they say he assumes pass on from the OEMs to the consumer. And he's explaining, no, that's not the case, that his methodology is based on factual assumptions derived from the industry expert reports. And what he does is he lists out the factual assumptions that underpin the approach that he's taken. And if the court would care to run your eyes over them, you will see that they are the familiar foundational matters that we've seen addressed in the industry experts' reports. And he says that's what's essentially driving my current approach. And at 2.8, it's clear that he hasn't identified any evidence which specifically takes issue with the propositions that he says underpins what he's doing. And so there's no reason for him to move away from his position at this stage.
And 2.6H is said to be based upon, can we just churn up that reference?
His first report, paragraph 5.8.
Well, which in turn is based upon the industry experts, because that's, in a sense, that's the key, isn't it?
So that will be supplemental bundle 6. And then paragraph 4.4c.
Paragraph which?
4.4c, so it's page 253.
Oh, yes.
Paragraph 4.4c, delivery charges are borne entirely by the first registered keeper of a new vehicle. They are not relevant to the used vehicle market. And then you see just a footnote there about contract hire. This is obviously in the section summary of conclusions, and I showed the court yesterday where they express this in the body of their report. He does, I'll come on to show you later in the report, address questions about the extent to which those could be negotiated away, because that's obviously an area where there has been further information provided.
I mean, that's the key complaint, which is that everybody knows that a significant proportion of buyers will not pay the list price, or at least it's sort of everybody's working on the assumption that not everybody just walks into a dealer and just pays the list price that's put in front of them. And if we're focusing on loss to the consumer, to the customer, the claimant, the objection is that you haven't produced a methodology that actually addresses the question of the effect, if any, of negotiating a discount on the list price on your loss.
My lord,
So,
yes.
and it may be in part because that may be based upon a legal misapprehension that discounts are irrelevant, in which case the question is, what effect does that have on your methodology? And if they are relevant, then how does your methodology propose to deal with it? That, at the moment, is how I see the battle lines between you.
My lord, that's certainly a summary of the differences between us, and I will come on to show you that Mr. Robinson recognises that as an area where a challenge has been raised to what he's doing, and he does address it.
Okay. But at the moment, that evidence, or that assumption, that point, 2.6H, is simply a statement, and I'm not sure, in fact, that the industry experts' reports grapple with that point, because they simply look at it from the perspective or the end of the telescope of the dealer.
My lord, they do, and what Mr. Robinson does is look at it from both perspectives in his evidence, and so he recognises the necessity to look at it from both perspectives.
I mean, do you accept or not that the ultimate question is whether the consumer has paid more for a car in the real world than they would have done in the counterfactual world?
My lord, no, that is the articulation of the distinction between us. We say, we very much accept, and this comes to a point that your lordship raised yesterday, your lordship characterised the nature of the MNW appeal against us as being that we have essentially violated a fundamental principle of tort law by failing to look at whether the price would have been different in the counterfactual.
So you say that even if the consumer paid exactly the same price in the real world as they would have done in the counterfactual world, they have still suffered a loss.
The difference between us is what price does one necessarily focus on. Our position is that you look at the before and after counterfactual of the delivery charge. Their position is that that's not the right approach. You must look at the before and actual on the car as a whole. We certainly do look at the counterfactual, but we dispute which element of the price one must look at for the purposes of that.
Well, that seems to be quite a major difference between you, and I would have thought that is a question of law, isn't it?
My lord, it is fundamental. We say it's a highly factually sensitive issue between us. We say that one can't simply make an assertion that one must look at the price of the car and one must not look at the delivery charge. It is necessary to have factual information about the way in which cars are sold. And whenever one gets into a debate about this, it's on certain assumptions. For example, my Lord Justice Snowden just said everybody knows that consumers might seek to negotiate. That's, of course, the extent to which they do, the way in which they do, the effects of their efforts to do so. All of that is a factual matter that requires to be present before one can take a view.
Well, that I understand, but is not the ultimate question, have the consumers paid more than they would have done for their car?
My lord, we say the ultimate question is, have the consumers paid more than they would have done but for the cartel? And whether the methodology must answer that question by looking purely at the delivery charge or by looking at the car as a whole is exactly the matter that is in dispute between us.
You just simply dispute their articulation of the counterfactual. Your counterfactual is different.
My lord, yes, we say that because of the nature of the delivery charge, the evidence we have that it is a silo charge and that it is industry standard practice to pass it on, a methodology can legitimately look at the delivery charge in order to answer that fundamental question, did they pay more in the counterfactual because of this cartel, we say it's perfectly legitimate for us to look at that charge in order to answer that
I
question.
can see that you may say, well, we've got this delivery charge, it's been inflated, it's been passed on to the consumer, and that you, the fact-finding tribunal, can infer from that that the consumer paid more for the car. But is it not open to the defendants to rebut that inference and say, well, no, that's not how things work in the real world?
My lord, it absolutely is. It's absolutely open to them to rebut that. And we say that is what will happen at trial.
Yeah, so in other words, I think you do accept that the ultimate question is, have the consumers paid more for the car? And one way of establishing that is to focus on the delivery charge, from which you can infer, absent other evidence, that they did pay more for the car.
Well, my lord, we do not accept that the test that one must look at, have the consumers paid more for the car.
Right.
That is the debate between us. We say when applying the counterfactual, it is a legitimate methodology for us to focus on the delivery charge.
But does it work this way? You both agree there's a but-for test, so you're both hypothesising the existence of some form of counterfactual.
Yes.
Your case is that, although it's not really expressed in this way, in 125 of the Cat's judgment, they took your case and said, there was pass on to the point of view of the retailer, there was pass on to the consumer, it was a differentiated negotiation or discussion about price, and whatever happens to the rest of the car price, delivery charges were inflated, and that's your analysis of what would happen in the counterfactual. You then say that's your case. The defendants say, no, you've got to look at the overall price, and so we need to know what's going to happen in the counterfactual. They put that up as their evidence. In your case, they have the burden of proof to establish that, because you said you've established some loss. They've said we're saying that there is no loss. And at trial, the tribunal is going to have to grapple with whose counterfactual is right, what happened in that counterfactual market, and how it compares with the actual.
My lord, yes. And it's essentially an absolutely standard situation where the parties put forward competing methodologies. It's not at all unusual for a tribunal or a court to be faced with two different methodologies taking two different approaches to trying to get to the same question. What has the consumer lost here? And the tribunal doesn't find itself completely unable to grapple with it. The tribunal will adjudicate, in the light of the factual evidence and the expert evidence, which of those methodologies it considers most robust, and it will determine the case on that basis. And the obvious example of that is the Britned case, which was the first case on cartel damages, which went all the way to judgment.
I'm afraid I'm still a bit lost. I understood you to say that what the defendants are proposing to advance as a case is legally irrelevant. I'm not sure whether you maintain that position or not. If you say, well, it's all a question of fact, then I can understand that. But at the moment, I think your case, as pleaded, if that's the right word, is that it is legally irrelevant to look at the overall price of the car. What I'm not sure about is whether you're maintaining that position or saying, well, it's all a question of fact.
Your Lordship is referring to paragraphs 69 and 70 of our
Correct.
reply. Both of those cases are there set out. We first say it's all a question of fact. What is the correct measure of loss? And that is the question which the tribunal said was a question for trial. We then said in paragraph 70 that there is a distinct legal argument, which is that even if you look at it from the perspective of the value of the car, the price of the car, then we raise the fault and shipping point, which is we say actually there's an extraneous benefit. They are two independent, in our submission, answers to the point. The tribunal upheld our position in relation to the first point, the fact that there is a factual dispute between us as to what you look at in order to determine the extent of a loss. And it found against us on the second point, and that's obviously the subject of our respondent's notice, which I haven't yet dealt with.
Yeah. So really, apart from the Fulton point, you're saying they're just factually wrong. To come back to my Lord's point about how you categorise the analysis of the counterfactual, you simply say they're just factually wrong, and that will be determined at trial.
That is the position we would advance at trial. Of course, at this stage, we don't even have to say they're factually wrong. We have to show that our approach that we have taken has some basis in fact under the Microsoft test. And we say that on any view, our industry expert evidence gets us over that hurdle.
Yeah. So okay, I'm now a little bit confused. You said a few moments ago that it's perfectly possible in these cases to have competing methodologies put forward. So do you read the Microsoft test and what the certification process involves as simply certifying on the basis of a methodology that you put forward, which doesn't need to take into account any of the issues that might be raised by the defendants, but just basically says, if we're right, this is the methodology which we will use? Because I'm struggling with a lot of the dicta that I've seen, which talk about the methodology being appropriate or suitable or presumptively so to address the issues to be determined by the court, which I took to mean the differences between the parties, one of which you say you've now identified, for example, which is the difference in approach between you and the defendants. Are you saying that the methodology that's referred to in the certification process, which the CAT was involved with, actually simply is only just to check that your methodology works on your own case, but has no relevance necessarily to any of the issues that are raised by the other side? And that they just come along with their methodology and say, well, actually, this addresses our case. And the court just merrily swans into a trial with two competing methodologies, neither of which is aimed at the issues as joined between the parties on the pleadings. Is that the way you say this is supposed to work? Doesn't sound very sensible to me.
It doesn't, my lord, and I think the reason is that there are two parts to your lordship's question. The first is, do I say that the certification test requires me to advance a methodology? And my answer to that part of your lordship's question is yes. We are entitled to seek certification on the basis of our proposed methodology, which must satisfy the Microsoft test. The second half of your lordship's question is, well, what do we do about the fact that the respondents may have a different perspective? And insofar as the respondents want to advance a different methodology, there is no bar to them doing that, and there is no bar to us interacting with that, challenging it, addressing it. As to what is required of our methodology has to be capable of being sufficiently flexible to respond to determinations of issues at trial. And that, in my submission, is a slightly different point than saying it has to be able to accommodate a completely different methodology that the respondents may advance in response to us. It means that insofar as some of the factual underpinnings of our methodology might be subject to challenge, it has to be sufficiently flexible to be able to accommodate that.
Right, but does your methodology, as I understood it, your methodology is based upon the premise that you're right in paragraph 70 of that reply document, which we looked at, because it basically says we don't, the methodology doesn't need to address the question of what happened in negotiation between claimant and dealer.
No, my lord, that is one of the two responses we put in that document. It stands alone. It's the Fulton shipping point. We do maintain it.
But if you were wrong on that, we'll look at the other one in a minute, but if you were wrong on that, and assume there's no other one, just for the moment, just for this hypothesis, if you were wrong and could be seen to be wrong as a matter of law on paragraph 70, would you accept that your methodology would need to be changed?
If I would accept that my methodology has to be capable of being sufficiently flexible to accommodate potential changes, and that's a distinction.
But suppose we said now you're wrong on paragraph 70 as a matter of law, you're just wrong.
Then my submission will be, I have put forward a methodology which has some basis in fact, which is derived from the industry expert's opinion, and which is sufficiently flexible to accommodate factual findings that the tribunal may make in due course on evidence challenging our methodology, and so it is a sufficient methodology for the purpose of certification. I can make that submission entirely independently of the point in paragraph 70 about fault in shipping.
Well, you can also say that that's what the CAC decided.
My Lord, indeed I do, yes.
That's a factual evaluation of your methodology.
My Lord, yes, which is to be accorded a broad margin of discretion.
And to be putting that, the Fulton point, into a factual context, your response via Fulton was to say that any negotiations and any discount from the list price doesn't matter. If you're wrong on that, in which case you've then got to address the question of negotiations in the counterfactual. The moment you have a slightly all or nothing approach, although Mr. Robinson said he'll deal with evidence as it comes up, do you accept that methodology at some stage must address that issue? Because that's now an issue. I know it's only been pretty broadly expressed by the defendants, but one can imagine that in defence and or in pleadings or in their own expert evidence, it's going to loom very large. We can see that from Dr. Madumba. Do you accept that you have to address that at some point, either now or later or at some stage?
I certainly don't necessarily accept I have to provide the answer now, because we are at a stage where we haven't even seen the full pleaded case from the defendants, let alone the evidence that on which they may rely. I accept that it's necessary for my methodology to be able to accommodate that as and when it arises, and we do say that it's possible to do so. Your Lordship raised with me yesterday the idea that we are looking at an aggregate award of damages, and so the approach that's taken has to look at the position of the class as a whole rather than individuals. That is an observation that Mr. Robinson makes in his report in express terms. It's 4.2.
Of which report?
His second report.
Second
Sorry,
report.
I managed to put my gown on the seat. 4.2.
Yes.
So he says, an additional point I would wish to make at the outset is that when considering the level of overcharge which was passed on to end customers, it's important to bear in mind that my analysis seeks to estimate damages at the level of the entire proposed class rather than for each individual buyer. This is necessary because it's not possible within the cost and time constraints of litigation and with limitations to the data which may be available to review each and every transaction. And he says, I'm instructed this is not required under the collective action regime where an award of aggregate damages is sought. Rather, I consider that my methodology, which relies on the industry experts' evidence as to how in practice the market operates, will arrive at a reasonable estimate of the passed on overcharge in the vast majority of instances and across the proposed class as a whole. He says there will inevitably be instances, of which the respondents have raised certain hypothetical examples in which I discuss further in this section, where the normal processes in the market may not hold. However, and this is his present assessment of the state of the evidence, based on the industry experts' evidence, these instances will be outliers and in a small minority, and as such, the estimation based on my methodology will therefore overall provide a reasonable and materially accurate high-level assessment of the loss suffered by the proposed class. So what he said there, two things really. First of all, he is applying the approach that my Lord Justice Green indicated was the appropriate one of looking at aggregate damages across the class as a whole. His present assessment of the evidence, based on the assumption that the industry expert evidence will be upheld, is that any outliers will be a minority, and so his methodology will accurately assess the loss to the proposed class. But in my submission, it is implicit in this approach that should they be other than outliers, he can accommodate that. Absolutely implicit, because of the nature of the exercise that he's doing, he's looking at the loss in aggregate to the class. If, in due course, he were to review the evidence and conclude, or indeed the tribunal were to review the evidence and conclude, that any instances which deviate from normal process in the market are more than outliers and are not a small minority, then the aggregate award can be adjusted to reflect that. In my submission, it's absolutely evident that that is the approach he's taken.
Yeah. And whether the industry experts are right is a question of fact, you say, for the tribunal to decide.
My Lord, yes. And indeed, that's what the tribunal said.
Lloyd and Google, I think it was Lord Leggett's judgment, where he said that when you aggregate damages, you contemplate the possibility that you will include within the recoverable class those who have suffered no loss, and you sort those issues out of distribution.
My Lord, yes.
Yeah. All right, where do we go from here?
I was just showing the court the various examples where Mr. Robinson is recognising either points have been raised, but he considers that nevertheless the analysis that he set out holds, or points have been raised which require revisiting. 4.13 is under the heading pass on of overcharge by OEMs to NSCs, and he's identifying a point made by Dr. Majumdar and KK about the theoretical possibility of incomplete pass on between OEMs and NSCs. He says, as a matter of theory, this is a possibility. He says it contradicts the evidence of the industry experts. And he says, I've not seen any empirical evidence, contrary to that of the industry experts, regarding how the automotive industry operates, specifically that passing on the cost of transporting the vehicle is accepted as industry standard. And you see again that he's saying, that's my assessment of the position at the moment, and then he indicates if during the course of proceedings the respondents were to introduce evidence which contradicts the assumptions put forward by the claimant's industry experts, I would consider how this may change my approach. And again, in my submission, that is a perfectly proper response in circumstances where the basis on which he's originally expressed his opinion hasn't at present been undermined. 4.33 is an example which goes slightly further in my submission. It's page 435.
I think your opponents would say there's something missing here. He deals with the pass-on of overcharge by OEMs to NSCs, and he deals with the pass-on of overcharge by NSCs to dealers, retailers. Where does he deal with the question of whether the price paid by the customer, your clients, included either all or part of the overcharge? Right?
He comes on to that in 4.34. But of course your Lordship will be aware that this is a responsive document, and if your Lordship asks where does he deal with that, the beginning of where he deals with that is of course his primary methodology, where he says, I rely on the industry experts.
Well, the Goss-Whitehorn report says that the customer pays it all.
My Lord, yes. And our submission is, at this stage, that is enough.
Yeah.
I was just showing you point 4.33 because this is an example where he goes slightly further than simply saying I will adjust if necessary. He's here addressing, you see again this familiar refrain that I've based it on the industry expert evidence. But he identifies a particular point. He says the industry experts have asserted that following a hypothetical decrease in shipping charges in the but-for scenario, delivery charges would remain static and the vehicle companies would enjoy a higher margin. In the event that this assumption is relaxed, as is raised hypothetically by the MNW respondents, KK and Dr. Majumdar, then he goes on to identify what would be the consequence in his methodology if you disregard that assumption. So he says there would be no delay in pass-on the basis that the but-for delivery charge would have fallen to reflect the lower costs, and thus the ongoing impact of the overcharge would have been passed on to the end customer. It's likely that the impact of this would be a higher level of damage to the end customer compared to a scenario where the industry expert's assertion holds. So he has commented on what would be the consequence if this theoretical proposition that's been raised would follow. And then he goes on to say, should robust evidence become available which would lead to such a relaxation of my assumptions, then my methodology could be adapted in due course. So in my submission, this is a slightly more concrete example than we've seen previously, where he says this is what the outcome would be, in broad terms, if I were to disregard that particular element of the evidence. And then from 4.34 onwards.
And I'm not sure that I entirely follow the logic, but it doesn't really matter. I mean, what he seems to be saying is if delivery charges go down, customers suffer more. I don't follow that.
My Lord, he's talking about if...
He has based his methodology on Goss-Whitehorn saying that even when delivery charges to the OEMs go down, the customer still pays the old delivery charge. That's what they say. There's a delay in passing on. And what Mr. Robinson seems to be saying, well, if there is no delay, the customer suffers more. I don't at the moment understand that, but it may not matter at this stage.
My Lord, it's to do with what we assume in the counterfactual, and the counterfactual being no cartel. Messrs. Goss and Whitehorn have said that in the that if delivery charges go down, which is what would happen if you didn't have a cartel, nevertheless, charges to the customer would remain static, and
Yes.
the companies would simply absorb the margin.
Yeah, absolutely. That's what they say. And what Mr. Robinson is commenting on here is a challenge to that. In the event this assumption is relaxed, i.e. delivery charges are reduced when shipping charges decrease, then there will be no delay in pass-on. The delay in pass-on is the pass-on of a reduced shipping price, as I understand it.
My lord, the delay in pass-on arises because Mr. Robinson's methodology is to observe the next increase in a shipping price, and he only identifies a pass-on of a charge from that point because of the data issues that he identified. That's why. So he's saying, I'm comparing to a counterfactual where we assume that the prices remain stable because the car companies essentially absorb the margin. If, conversely, in my counterfactual, the prices were to go down, when I compare what the consumer is paying in the factual and the counterfactual, I find that actually they've suffered a higher overcharge.
Never mind. Still don't understand it, but it doesn't matter.
It may be that the point is not really the content of his reasoning, it's that what he's giving a concrete example of the way in which his methodology would be effective.
Yeah.
4.34 and following. This is Mr. Robinson specifically engaging with the point about whether or not an overcharge would be negotiated away. And the court will recall that that was no part of his first report because he considered it at that stage irrelevant based on the position of the industry experts. The respondents then raised the point in their responses to the CPO application, and so here we see Mr. Robinson responding substantively to the arguments that have been raised. Paragraphs 4.34 to 4.39 are Mr. Robinson summarising the fairly detailed criticisms that have been advanced against him, and he refers in particular to the things that Dr. Majumdar has dealt with in his report, and he also, at paragraph 4.37, specifically flags up the position of the MNW respondents that calculating damages should involve comparing the overall vehicle price paid by the end customer in the but-for and the actual scenario. So he's specifically responding in particular to the point which we now see before this court. And paragraphs 4.40 to 4.44.
Can you just explain 4.39 to me? I'm not sure that's quite the point, is it? I don't quite understand the point he's making in 4.39. I mean, the counterfactual, as I understand it, is no cartel, which means reduced delivery charge.
Well, subject to the point about the industry experts saying actually in the counterfactual, insofar as costs fell, they would nevertheless be maintained. That's a slight wrinkle on that assumption.
Okay, but maybe a wrinkle, but I understood that the point being raised by the respondents was not that any increase in the delivery charge may be negotiated away, unless by that he means the increase which results from the cartel being in operation.
I think, my lord,
Right,
he is addressing it in terms of an overcharge, yes. He's asking, is it possible that an overcharge could be negotiated away?
But then he goes, this is because on their presentation, the end customer is generally concerned with the total end price of the vehicle and so would be resistant to any increase in the total price. What? Nobody's suggesting that the customer is going to be faced with an increase in the total price. As I understand it, you've just got the real world. What did the customer do? Did they negotiate a discount on the real world price they were presented with, which is the cartel in place price? And the question is, the counterfactual is, subject to your wrinkle, a reduced price. And the question is, by comparing the two, was what the customer paid different in the real world and the counterfactual? Hence, have they suffered loss? I'm not sure that's quite the point he's addressing, is it?
Well, my lord, I think it may make more sense if we look at how he analyses the extent to which the customer's negotiating behaviour would change in the counterfactual, because what he looks at is the extent to which the amount represented by the overcharge, which its common ground potentially could be small, would make any difference as between the factual and the counterfactual.
But where this is going to get to is he says, I don't need to change my methodology to deal with this point.
It comes to the point where he says he thinks that the likelihood that negotiations would change the position as between the factual and the counterfactual is very small. And so he's commenting substantively on the nature of the respondent's case, and he's saying he doesn't think that it would make a difference, and consequently it is legitimate for him to continue to rely on the fact of this siloed charge as on the basis of what the industry experts say.
Yeah, and whether he's right or wrong about that, you say, is a question for trial.
My Lord, yes.
All right. I think we need to press on.
I'm grateful, my Lord. Just to finish off this point, 4.40 to 4.44, he's analysing the content and the import of the witness evidence. And 4.45 to 4.57 is where he gives his expert opinion on the extent to which the delivery charge will have been regularly negotiated away. And so the point I make is that this is an additional layer to his analysis in circumstances where he hasn't previously considered at all.
Yeah, and he says that if all car rental companies refuse to pay it, then he can accommodate that.
He says that the negotiating characteristics of the parties will be the same in the but-for and the actual. Yeah. And so one must ask, to what extent would their behaviour change because of the presence of the cartel? He looks at it both from the perspective of the retailer and from the customer. And that's the point I understand my Lord Justice Snowden has been emphasising. From the perspective of the retailer, he says the motivations to cover the cost will be the same in the but-for and the actual, so there's no reason to think that that would change, and he relies on the evidence to that effect. From the perspective of the purchaser, he points out that this is necessarily going to be a small price differential on the overall price of the car, even smaller if the car is bought on finance, and so he says it's unlikely to cause a buyer to adjust their negotiating position or factual compared to the counterfactual because it's so small, and that is essentially a point that's common ground between us. And so he says the requirements for increases in the delivery charge to be regularly negotiated away such that it impugns his analysis. He said two things would be necessary. First of all, indifference on the part of the seller with respect to the recovery of their costs. And secondly, a strong response by the customer to small price increases such that they change their negotiating behaviour. And he says on the present state of the evidence, he considers that to be an unlikely scenario.
Yeah.
But this is where we come to a point where he does identify a possible adjustment. 4.56. He's here referring to the possibility that buyers might focus their negotiations specifically on the delivery charge rather than generally. And he refers to the evidence that you've been shown of Mr. Dent, that would happen very infrequently. And he refers to the evidence of K-Line's witness, Mr. Cunningham, about fleet purchases, which he says, he analyses that and says, well, it contains minimal details as to whether negotiations would focus specifically on the delivery charge. And then we get the 4.57, even if all car rental companies were able to refuse to pay the delivery charge in its entirety, that could be identified and would not have a material reduction on the estimated claim. And he gives an example of how one might essentially adjust the claim to reflect that assumption.
Yeah.
Now, Mr. Singler was somewhat critical of that example of an adjustment, and he said, oh, well, it's a very straightforward adjustment, it's a very easy adjustment to make. But that, in my submission, misses the point, because this is the only example where, in Mr. Robinson's view, there was any real evidence at this stage which it might be thought was potentially capable of contradicting the basis on which he has proceeded, and so he indicates the basis on which that adjustment could be made. And that's why he's chosen this particular adjustment. So in my submission, the 3 points that come through from the entirety of Mr. Robinson's evidence are, first of all, his proposed methodology is very much driven by his awareness of the data availability issues, and I showed you the paragraph in his first report where he explains that. Secondly, he has engaged with and responded to the respondent's methodology where appropriate, and he's made clear that his methodology is capable of adjustment if necessary. And And thirdly, and specifically in response to the respondent's case that was raised against us, he's expressed his view that it's highly unlikely that any overcharge located in the delivery charge would somehow be offset or negotiated away in focusing on the overall price of the vehicle. So he has substantively grappled with the point that's being put against us.
Yeah.
That brings me to the end of the lengthy excursion through the report. So I'm hoping that having done that, my submissions on the two appeals can be taken relatively swiftly. Starting with the MNW Appellants appeal, obviously Ms. Demetriou says we've focused on the wrong thing. We've looked at the delivery charge and we should have looked at the value of the car. And I've emphasised that it's not the case that we are not looking at a counterfactual at all. It's that we differ, parties differ, as to what the counterfactual has to focus on. They say you have to look at the car, we say you look at the delivery charge.
And then critically you say your methodology at this stage doesn't have to engage with their case. It's good enough that it follows your case. It might have to change in the future, but that's not an issue for now, you say.
I say that satisfies the Microsoft test. There's some basis, in fact, for our approach. It is sufficiently flexible that it can accommodate findings to the contrary in due course. It's claimed that the dispute between us is a hard-edged question of law, but the submissions that were made on it were based on a series of examples and suppositions and assertions about what happens when a consumer buys a car. And there's no evidence whatsoever on any of that, either before the tribunal or before this court. There's no evidence about how list prices are set. There's limited evidence about how consumers negotiate. And there's no evidence about the relationship between the delivery charge and the overall price. So everything that's said about this is the reason why you should, as a matter of principle, focus on the overall price of the car, that is essentially based on factual assertion rather than evidence.
Well, sorry, wait a minute. Are you saying that this court or the CAT couldn't at least take some notice of the fact that, well, A, the evidence says that a proportion of the class will have bought cars where the price was an on-the-road price, which did not contain a identified line item for delivery charge. That's in the evidence. And that the CAT and this court should ignore the possibility that customers get a discount on their cars when they buy them. Are you saying that there's no evidence of that?
My Lord, can I take those 2 points in turn? The first point your Lordship raised is the fact that in some cases there isn't a line item. Insofar as that is a concern, we say that it isn't for the reasons I've shown you in the industry report. Insofar as it is a concern, it is a classic example of the sort of adjustment that could be made in due course in order to extract those claims. If it were to be found that that's a crucial distinction because for some reason that pass-on doesn't happen simply because there's no line item, your Lordship will have well in mind that we don't accept that that's a valid distinction. But if it were, one could identify the proportion of claims represented by that factual scenario and take them out. It's very easily accommodated within the approach that Mr. Robinson himself says he's taken, which is the aggregate damage to the class.
Yeah, but sorry, I thought the point you were making, the point you were making is that there was no evidence to substantiate the possibility that somebody might have bought their car focusing on the overall price and obtained a discount.
My Lord, I certainly make the point that it is insufficient for the purposes of deciding this fundamental dispute between us to take judicial notice of the possibility that somebody might have negotiated and obtained a discount. In my submission, that is fundamentally insufficient factual basis on which to decide the factual question whether or not one must look at the delivery charge or the price of the car. It is a very factually sensitive issue. If I can introduce just one more example into these proceedings, and this is an example that I canvassed with the tribunal below, and it caused a certain amount of humour, but it is in my submission a useful example. Assume that you go into a shop and that you want to buy your lunch and you buy a sandwich, a bag of crisps and a banana. And you're given a receipt which separately itemises each item that you bought. And assume that there is a cartel in bananas. Does that mean that an economist who is seeking to quantify the impact on you, the consumer, of the cartel in bananas has to analyse the total price of your lunch? In my submission, clearly not. Self-evidently not.
No, but that assumes I've paid, which I'm afraid if I go into Pret I probably will, the stated price, and I don't walk up to the till and say, hang on, I'd quite like a 10% discount on this.
My lord, it assumes a lot of things, and that is very much the point I'm making. It is a factually sensitive
I've got no
example.
problem if this was a cartel in bananas, and you can pretty much take as read that people don't negotiate the price of their lunch in Pret, or whatever place you go to, let's be clear, it's not just Pret. But that's quite away from this point which has been raised against you, which is that some people may, but there's at least a reasonable prospect that some people don't pay the list price for their cars, and your methodology at the moment doesn't accommodate that.
This is where aggregation is relevant. I mean, that aggregation assumes that there will be a multitude of different permutations in the class, and at some stage the CAT will have to grapple with whether the degree of divergence from the norm is so different that they have to then take it into account or not. It's not certain we've actually had to address ourselves to this precise issue. We've looked at aggregation on a couple of occasions, but quite how the CAT at a trial makes adjustments in an aggregation case, it raises some quite difficult issues.
But it's certainly, in my submission, what is contemplated in your Lordship's dicta in Gutman, the expandable axe head and the practical approach to justice and all of those factors, the CAT can and must grapple.
Yeah, I'm sure they can do it. I mean, with the assistance of the parties and the number of experts there's going to be in the hot tub, you'd find a way of doing it. This is almost a more point of principle. If there are divergencies, so for example, there are individuals who do negotiate and the CAT says, well, right, it's 5%, they can figure out the 10%. At what point does the CAT then start to make adjustments in an aggregated damages case, recognising that, as Lord Leggett said in Lloyd and Google, there is a degree of flattening and uniformising, homogeneitising, if there's such a verb, in a class action case. But I suppose that simply leads to this. The mere fact there are differences doesn't necessarily mean to say there will be adjustments. But if there are adjustments to be made, which will be for the CAT at trial, they can be made, or would have to be made in some way, shape or form.
It's necessary to be satisfied that there is nothing to preclude such adjustments. And one certainly does not need to make them now. That's.
Yeah, your point is your method, even if that's the case, your methodology now doesn't need to address those questions, provided it's capable of being adapted over the course of the proceedings at some point. Is that
It needs to
what
be
you're essentially
capable
saying?
of addressing those sorts of variations insofar as they are found against it. And in my submission,
And the CAT
our
could,
methodology
the CAT
clearly
could come
is.
back to you and say, for example, following further particularisation of the defence, say, well, actually, we now really want to know your answer to this, or how this is meant to be addressed at trial, because it's all rather vague and airy-fairy at this stage.
My lord, indeed, and absolutely at that point, we have a number of ways in which we can engage with it. We can adduce our own factual evidence about the factors, about how consumers negotiate, the extent to which consumers negotiate. We can adduce evidence about how list prices are set. We can adduce evidence about the interrelationship between the delivery charge and the overall list price. We will, of course, have the opportunity to do that as and when the full issues are pleaded out between the parties. And then there's a round of disclosure and evidence and further and expert.
One of the things I'm slightly baffled by, we've mooted between ourselves, is precisely what evidence you need to establish the counterfactual. What would you be looking for by way of evidence to establish how the market would operate without a cartel? What is that body of evidence which would have to... Maybe it's a question more for the defendants, but I understand the logic of it. It's an obviously logical point to take. Question how you prove it, or what evidence is going to be relevant to it, between a consumer on the one hand and a carrier on the other hand, with none of the vehicle sellers in between in court. How is that going to be established?
Well, my lord, obviously Mr. Robinson's position is that actually very little would change in the counterfactual for the reasons that he's canvassed.
But the case against you is that it would change. So
Indeed.
the CAT's going to have to grapple with this, and I'm just wondering what sort of evidence. Maybe it's a premature question to ask, but I'm.
Insofar as we're able to ascertain what is being said, it's not said that the fact of the overcharge changes the negotiations. It's being said that the way in which consumers habitually negotiate, for example, they might pick a round number and say, I want my car for £20,000. That would have certain consequences in terms of pass on, and of course, evidence can be produced as to the way in which consumers do that. And it's also, as I understand it, said against us that the way in which list prices are benchmarked across other car manufacturers would have consequences to the extent of pass on, because they might say, well, irrespective of our input costs, we look across and we see our competitor is selling out an equivalent model for X amount, and so that's how we're going to set our list prices. And then it will be up to us to argue as the extent to which that impacts on the pass on of an itemised charge. And obviously the court's very aware of our case on that. But
and so in both, in your counterfactual variation and the defendant's counterfactual, there would need to be evidence explaining both how the supply side viewed the question of negotiation, what they were prepared to bend on and what they weren't, and consumers' views. The consumers, of course, everybody is oblivious to the existence of the cartel. You remember we had this in Stelliantis. If you don't know there's a cartel, you're not focusing on that component, which would, I mean, if you knew about it, you would say to your dealer, well, I'm not going to pay this charge because, look, they've been found to be guilty of a cartel and I'm just going to knock 25% off. That's the overcharge. If you don't know about it and you negotiate globally, there may be a pro-ratering exercise. But your case is they would have to simply grapple, you'd have to find evidence which address both versions of the counterfactual, both variations of the counterfactual.
My lord, yes, and both parties have made a preliminary start on that. And so we've seen, for example, KK has put forward Mr. Dent, who is a retailer.
Yeah.
They put forward Mr. Cunningham, who is a fleet purchaser.
Yeah.
We, for our part, have put forward our industry experts who have
Right.
including retail experience.
Okay, so it won't really be based on disclosure or data. It's going to be based really on a trade expert witness evidence.
Well, I hesitate to say never in the sense that I would want to consult with our experts to see what they felt was necessary, but certainly that's the way in which
understand. Okay.
it has so far been approached.
Okay. Yeah, I understand.
And I'm reminded that there are various other options which may or may not be relevant. So, for example, behavioural economics experts might have something to say about how consumers engage consumer surveys. In terms of disclosure, invoices, I think that's what that says. And of course, all of this emphasises that this is a very fact-sensitive issue that the CAT will grapple with in due course, but certainly is not a basis on which to refuse to certify. So we do resist the characterisation that's put forward by the MNW appellants of their appeal, saying that this is a hard-edged question of law. We say no, it's not. And we say the tribunal quite rightly recognised that it was not, and I'm going to come on to that. Before I do, I just want to address the criticism of our pleading. We're criticised for not having pleaded a case which concerns the value of the car, and it's said that what we should have done is to accept that the right measure of loss is total transaction prices, but then to say that we think that it will be difficult in practice to obtain data, and so what we've done is looked at delivery charges. That's what is suggested we should have done. And the fundamental objection to that is it is not our case. It is the respondent's case. And I've shown your lordships the content of the Microsoft test, and it says nothing about being obliged to plead a case which you do not think is right. And it was then said, well, had we pleaded a case that the respondents think we should have pleaded, then of course the tribunal can scrutinise the evidence and decide whether it stacks up. And my submission is nothing is preventing the tribunal from doing that anyway. And indeed, we've already begun the process in the passages that I've shown you from Mr. Robinson's second report. We don't have to plead the case the respondents think we should be running in order to engage with it. It's also said that the flaw in our methodology is that it doesn't permit the question to be examined at all. And in my submission, the exchanges that we've been having demonstrate that there are many possible ways in which the CAT can purport to examine this issue. It certainly doesn't find itself helpless to determine the issues before it. That's exactly what the tribunal said in its judgment. We look at tab 11, page 160. Actually, can we start at 155? I just pick up in passing paragraph 56 of the tribunal's judgment. A passing comment was made that the tribunal hadn't addressed or doesn't address in a particular passage MNW's strikeout argument, and I just draw the court's attention to 56, which is where the strikeout argument is addressed by the tribunal, and it says we've concluded the applicant's case should not be struck out in whole or in part, and that summary judgment is not appropriate. The reasons for these conclusions are set out in the discussion of the eligibility conditions that follow, and in particular our conclusion that the proposed methodology is sufficiently plausible to meet the common issues requirements. So they say that explains why it's not being struck out as well, and in their submission that's quite right. The parties recognise that the point goes to both. Paragraph 70. This is where the tribunal correctly directs itself as to the legal test, the Microsoft test. Paragraph 76. We see the tribunal emphasising that there's no rule that confines the concept of a methodology to a particular econometric technique or to the expert evidence of economists. A methodology is no more than a method, whether devised by economists or other experts or both, that is sufficiently credible or plausible to establish some basis in fact for the commonality requirement. As discussed below, it might, as in this case, be derived from a combination of industry expert evidence and expertise in economics. That, in my submission, is a particularly relevant observation in circumstances where Mr. Singler was advancing below, and again in this court, criticisms that, in his view, our economist wasn't doing what one would normally expect economists to do. The tribunal quite rightly points out that it's not necessary to confine methodology to particular econometric techniques. 77 to 94, in fact, is a lengthy and thorough summary in our submission of our methodology. And we draw attention in particular to paragraph 93 on page 167. The tribunal's assessment is that Mr. Robertson has made clear that the methodology is necessarily provisional at this stage. Data disclosed by the respondents or evidence adduced could have an effect on the analysis required to assess the overcharge. It's recognising the need potentially to revise the methodology at a later stage. Paragraph 95, we see the summary of the two key objections that were raised on behalf of MMW and endorsed on behalf of KK, and then it says the third objection was raised on behalf of KK. The first is obviously the point that Ms. Dimitriou now makes before this court, and the third is the one that Mr. Singler now advances. 96, we see again the tribunal emphasising that there was a tendency on the part of the respondents to regard the methodology proposed by the applicant as being confined to the method of calculation proposed by Mr. Robinson, and this is a point that my Lord Justice Lewison raised yesterday, and the tribunal indicates that that's too narrow approach and explains the basis of Mr. Robinson's calculation method. Emphasise that each stage he addresses the availability of data required to allow the methodology to be applied, whether from disclosure or other.
It's really paragraph 111, isn't it, where they reach the conclusion that the methodology is sufficiently flexible for any successful evidential challenge to the quantum to be addressed.
My Lord, that's one response to Mr. Singler's, in particular Mr. Singler's challenge, and I do very much rely on that. I would just draw the tribunal's attention, the court's attention, I apologise, to, first of all, paragraph 96.4, where the tribunal is citing from the EC pass-on guidelines, and it's referring to the fact that it's further authority for the proposition.
So you mean 98.4?
My Lord, I do, yes, I apologise. 98.4. No technique should be singled out as always being more appropriate. Although econometric techniques may in most cases increase accuracy, they require significant amounts of data that may not be available, or there may be considerable cost in obtaining it. Other quantitative evidence may play an important role in determining whether any or which of the quantitative techniques described in the guidelines can be used. So it's recognising there the validity of the approach we have taken based on the industry experts. Paragraph 100 is informative in response to Ms. Dimitriou's argument that the tribunal has determined against us the question of fact as to whether one looks at the delivery charge or the car. The tribunal is summarising the conclusion they've reached. It does meet the Microsoft test. And the first challenge, that's the one advanced by Ms. Dimitriou, raises issues that are properly ones for trial. In particular, the grounding of the methodology and the evidence of the industry experts. I mean, it's not purely theoretical or hypothetical. Mr. Robinson also carefully considered the likely availability of factual data to allow the methodology to be applied. Lord Briggs described as the low threshold of some basis in fact for the commonality requirement being in this context the issue of whether and to what extent there was pass on to the classes in our view met. The methodology offers a realistic prospect of establishing loss on a class-wide basis. So this is both the summary of the tribunal's finding that the Microsoft test is met, but also a concise explanation of the basis on which it's rejected Ms. Dimitriou's point, and it says it raises challenges that are for trial.
I think what may be underlying some of my questions to you, picking up that sentence you've just read to us, is if the commonality requirement is the issue of whether there was pass on, the methodology and probably addresses the question, but it's the issue of whether and to what extent there was pass on, I think is the concern, because it's really the and to what extent which is addressed. I think what's really being said about the whole sort of question about discounting of the price and what happens between customer and retailer is really focused on this question of to what extent there may be loss suffered. I'm hesitating. I'm trying not to use the word pass on, okay, which is a...
Lord, yes.
Okay, that's just code for overcharging loss, I think. But it's when the common issue is supposed to be not just whether, but to what extent. That's where I begin to get more uncertain, shall we say. But that is the way that your pleading defines the common issue. That's not just the tribunal. That's lifted from your pleading. The common issue which your methodology is said to address is not just whether, but to what extent as well. And that's where I just have that, I struggle a little bit at the moment still with the disconnect.
My Lord, we don't shy from the fact that the issue is both whether and to what extent. Mr. Robinson's methodology, I hadn't troubled this court with it because it's perhaps too much detail, but he does set out a series of scenarios where he considers whether or not pass on would be 100% or something less than that, and in some of the scenarios he identifies less than 100% pass on. Yeah,
but that, again, let's not use the word pass on. Down to retailer, I understand there may be scenarios where not 100%, but it's the question that I'm still focusing, I'm afraid, like a dog with a bone, between retailer and customer. And that's perhaps where I think it may be you say that will have to come out in the wash over the period of the proceedings, depending on what actual points are made in the pleadings in defence.
My Lord, I certainly do say that. And I do say that the slight difficulty we face in responding to your Lordship's question is that Mr. Robinson has looked at this point and he remains confident that, in fact, the circumstances where the charge would be negotiated away are relatively small. And now that's being raised against us as suggesting that he's not able to accommodate that possibility, whereas, in fact, his assessment is actually it's very unlikely. But he's certainly not saying that that can't be accommodated. It's simply that he considers, based on the evidence that he has seen, that actually the chances are there are very limited circumstances in where that arises.
Yeah, and that's what the CAT concluded.
My Lord, yes. Just to address the dispute between us about whether the tribunal has decided this point against us or not. In our submission, paragraphs 120 to 124 are where the tribunal considers and rejects the Fulton shipping point, which I'm going to come on to address.
Yeah. So then they say it's all a question of fact for trial.
And then they say it's all a question of fact for trial, my Lord, yes. we resist the interpretation of this judgment advanced on behalf of the MNW Appellants that actually that point has been decided against us by the reasoning in Fulton Shipping. We say it's a separate and discrete.
Yes, and one really has to start with 120, which is Mr. Dimitriou's primary case. The CAT then says your Fulton point doesn't wash. You don't get assistance from Sainsbury's. And then, in a sense, the context of 125 is how does this respond to the defendant's counterfactual point, which I suppose the crucial lines, although it's somewhat condensed, in the latter half of 125, the evidence of your expert is delivery charges are separate, must be recovered, not wrapped up or considered as part of a single undifferentiated price considered separately. That's a very condensed encapsulation of a response to a counterfactual. It says it is undifferentiated and it is wrapped up. You simply say in the counterfactual that's not what happens.
My lord, that is right. That is articulating precisely the factual dispute between us that the CAT has rightly deferred to trial.
In an ideal world, they might have spelled out how that actually related or addressed the defendant's point, but I think that's essentially the riposte, which they say, okay, it's for trial.
The question of what one focuses on as a question of to determine the loss is for trial. They do then go on to comment on some of the other ways in which we've engaged with it. So, for example, 126 is summarising Mr. Robinson's evidence on negotiations.
127 is more important, where they say the defendant's counterfactual analysis has not been yet subject to evidence,
I would, yes.
expert or otherwise.
And they go on to say that they're satisfied that insofar as...
They go on to say that it could be adjusted, the award could be adjusted in that same paragraph.
I would, yes. So that is the other way in which our methodology could accommodate findings, and they've given a concrete example based on what Mr. Robinson says in his report. And we say, insofar as there's any doubt about what they were finding, that's very clear from their finding on permission to appeal, which is in tab 13 at page 213. The tribunal expressly records in paragraph 17 the basis on which it was put to them by the MNW appellants that they should grant permission to appeal. They say, having rejected the applicant's argument that as a matter of law, loss could be established solely on the basis of cartel's impact on the delivery charge, the only conclusion open to the tribunal was that the applicant had not advanced any methodology for establishing loss. So that was what the MNW appellants sought to persuade the tribunal was the basis for appeal. And the tribunal says we refuse this application. In summary, it will be for the applicant to prove its case at trial. In particular, this will include demonstrating, in accordance with the evidence of its industry experts, that delivery charges are indeed treated as a separate cost item which must be recovered, such that increases in delivery costs are not absorbed. So that is the passage that my Lord Justice Green has just emphasised. The applicant will have to prove its case at trial that the overall price is not relevant on the facts, because delivery charges are considered separately, and it was not the case that discounts were negotiated or list prices were set in a way that would have differed in the counterfactual. The respondents will obviously be fully entitled to challenge the applicant's evidence, including by reference to the evidence and submissions about the total price. In my submission, that makes very clear that the tribunal was not purporting to decide against us the question of what is the correct analysis of loss. It's saying we've reserved it. I'm moving on to deal with the Fulton shipping point. And the Fulton shipping point is the basis on which the appellants say, well, actually, this has all been decided against you. But, of course, the Fulton shipping point is really a very discrete point. And it's the one I articulated earlier, which is if you assume that you have to look at the question of loss from the perspective of the MNW appellants, you have to look at the overall price of the vehicle, then we say that the class member, insofar as they've achieved a favourable price for the vehicle overall, that's an extraneous benefit which must be disregarded in computing the loss to the class. But that's a separate and discrete point which obviously the tribunal did not find in our favour, but it's not a basis on which to dismiss the factual dispute which it has reserved for trial. So starting
Can you just so we actually understand what the point is? I mean, I think I've understood it, but you'll probably explain it in a way which makes it clear that I don't. What's the benefit I mean, let's take Fulton, where the vehicle, the vessel owner had two sums of money. They had the sale, $27 million, and they had damages for repudiatory breach of contract. So two sums of money.
Yes.
And the argument was you set off the incremental profit from the early sale against the damages, 20 odd million against damages for repudiation. In your case, you simply got a price. There's not two sums of money. Where's the benefit which you say you're entitled to, in a sense, grasp and take without it being set off? Your customers paid a price. There's a total sum of money which is available from defendants. It's a total pot called 100%. You share it with everybody up the chain. Whoever suffered loss can get that 100%. Where's the benefit? Why isn't this just the application of the compensatory principle, which simply says you've suffered a loss, you can recover the loss. That's it, full stop, period.
My lord, this also relies on our industry expert evidence that it's not the case that we have paid a single undifferentiated price, or that the class member has not paid a single undifferentiated price. The class member has paid a separate itemised delivery charge, and they have negotiated, as between themselves and the retailer, the price, the overall price of the car.
In some cases, but not all.
Well, indeed, but insofar as we are looking at the relevance of the overall price of the vehicle.
But you haven't paid anything to the shipping companies. All you've done is enter into a transaction with a retailer.
My lord, that is a point that I rely on in my favour, because the cases say you have to ask, does this benefit, and by benefit I mean that part of the price which was agreed as between the consumer and the retailer, can the cartellist take the benefit of that? Can they rely on it to reduce the loss that they have caused? And the cases direct the attention to say, well, is there any causal link between what the cartellist did and the benefit that the consumer now gets?
But your clients don't suffer any loss unless and until they buy a car.
I know that's quite right, and you're not just putting to me the point that it's the same transaction.
Yes, exactly.
But my submission is that is true, but it is not an answer to the inquiry that the case law directs, which is, is this benefit causally connected to what the cartellist did? And the cartellists had nothing to do with the price that the consumer manages to get when they negotiate with the retailer. They can't in any way claim to have any relationship to that negotiation. And so any benefit that the consumer gets by having succeeded in negotiating a good price for a car is not something, as a matter of legal principle, that the cartellist can point to and say, I'm entitled to take the benefit of that in reducing the consequences of my wrong.
You're right in the sense that it's a benefit from a third party because the seller is not a cartellist. One of the problems with the case law, they're mainly contract cases where you're in a direct contractual relationship with the wrongdoer. So, for example, Fulton talks about a causal relationship flowing from the breach of contract. Here we're dealing with tort, and we're looking at something, we have to work out what the equivalent of contract is in tort. And it may be, are you contemplating the same line of transaction? Is it foreseeable? And here, when the cartellists look down the line, they make an assessment of the extent to which they can shove higher prices on their customers and have them passed on. So the mere fact it's a third party, I'm not certain necessarily gets you home. It's the same line of transaction. Well, once uses that rather, but and it's a tort case, not a contract case. I mean,
My lord, we've cited two tort cases in our authorities. One is Needler and the other is Allianz. The Needler, the way in which the Needler test articulates it is to say, Needler was a negligence case. It says whether the negligence which caused the loss also caused the profit, in the sense that the latter was part of a continuous transaction of which the former was the inception. So it's applying a causation test, and it's saying, having identified the wrong, the negligence, can you say that negligence caused the profit? And the submission we make is that one can't say that the wrong in this case, the overcharge, the cartelisation of shipping, in any way causally relates to the price that the consumer agrees with the retailer.
But
they
expected it to be passed on. I mean, that was, if you're up there and you're the cartellist, you're looking down and you're saying, all right, 10 quid a vessel, overcharge, 100 quid, whatever it is. It's a very small part of the price which our customers are going to pick up. When they pick up the vehicle at Felixstowe, it's no one's really going to notice. They're oblivious to the fact we've got a cartel. They'll just simply pass it on. It's a hard cost. You know that, and that's, I mean, almost the more wicked it is, the less helpful it becomes to you. But it's still within the same line of that transaction and expectation. You talked about continuous transaction in Needler. I mean, isn't this what we're talking about here?
I positively rely on that. It's quite right that one might say the cartellist expects it to be passed on, and that's why the cartellist bears the responsibility for that proportion of the charge which is passed on to the consumer.
Yeah.
But we draw a distinction between that and the overall price of the car, which derives from a negotiation between the retailer and the customer. That is distinct from...
Well, if you're right on your basic proposition, in a sense this might become irrelevant, but as I understood it, this is where maybe I misunderstood the case. I understood you were saying that if there was a negotiation so that the overcharge, which would have been 10 at the level of the retailer, becomes 8, you can claim the other 2, even though you haven't borne it.
No, we are not seeking to claim it. We are saying...
Well, it's irrelevant. You can still recover 10?
We are saying that the cartellists are not entitled to take the benefit of that reduction to reduce their liability.
But they don't, because someone up the chain...
relationship.
But the retailer then maybe has a claim for the 2.
Well, we're certainly not concerned with the extent to which the retailer has a causal relationship, but what we are saying is that there is an independent transaction which takes place at a different time between different parties on a different market.
Well, I think your answer to my Lord's question is yes, they are entitled to claim the 10, even though they've only paid 8.
We only seek to claim that overcharge which is established to have been borne, but we say in calculating that amount of the loss, it's not open to the cartellist to say, oh, well, you got a better price on the car. We're entitled to have the benefit of that, because there's no causal relationship there between what they did.
If you succeeded on trial on that, you don't need this argument. That's just simply you winning on the counterfactual. I'm not certain if you agree with the way our Lord is putting it. Let's just assume at the point of the retailer it's 10. You negotiate it down to 8.
I mean, the overall price of the car.
The overcharge.
The overcharge.
Yeah. Just the delivery.
It may be that's
the overcharge is 10. You negotiate it down to 8. Are you recovering 8 or 10?
It may be that's where the disjunct occurs, because the premise of this argument is that there is a separate charge which is borne by the consumer.
Yeah.
And the question is whether if the consumer negotiates down the overall price of the car, whether that is to be treated as a matter of law in reducing the overcharge from 10 to 8.
It's quite different then. You're not saying you can recover 10. You're saying you can recover 8. And you're saying that what happens in the overall negotiation, if there's something which is negotiated downwards, which could be set off against your 8, then that's not to be set off against the 8. Is that right?
I'm not quite following your scenario, why the 10 reduces to the 8, because the proposition we're advancing is that there is a separate siloed charge which is borne, and one doesn't reduce
I'm assuming there's a negotiation which does, on the overcharge, which reduces the overcharge from 10 to 8. So your actual loss is then 8, because that's the overcharge that you've borne. You're not, I think, then saying you can actually recover 10. So the retailer puts to your client, here's the price of the car, here's delivery, and you say, well, I'll have 5% off the car, and I also want 20% off the delivery.
Insofar as there is a negotiation which specifically focuses on the overcharge, we accept that the amount of the reduction cannot be recovered.
Okay.
But this argument is focused on a different point. Okay,
this is why I wasn't certain I understood it. You're now saying that if there is some negotiation on the, let's assume you're right on the silos, the overcharge you've got down to 8, on the car as a whole, save for your silo, your overcharge, there is a negotiation. You're simply saying, if there's some benefit, that's irrelevant.
That's exactly what we're saying, my lord, and it is relevant because the primary case that's put by the MNW respondents is not to say, well, there's some sort of negotiation specifically on the overcharge, and it's actually quite to the contrary. If one looks at paragraph 8 of their skeleton, the example they give is a Vauxhall car.
Yeah.
They emphasise the low amount of the overcharge, and they say it makes no difference to the negotiation. So their primary example is to say, let's assume that there's no negotiation on the overcharge itself, but let's assume that the consumer negotiates it down to £20,000. So we're talking about a negotiation which takes place between the retailer and the customer, where the customer succeeds in obtaining a discount. And there is an important question of principle as to whether a cartellist, who is up the chain, divorced in time from that entire process, is able to point to what the customer has done and say, I'm entitled to the benefit of that to reduce my liability, because the consumer overall has managed to reduce the amount for which they pay the car.
I think your point is, as I understand it as well, that this will depend upon factually what actually happens. I mean, if the consumer goes into the dealer and says, okay, the car's going to cost £25,000, and I can see that there's also a delivery charge of £1,000 on my invoice. I want a discount on my car. And the dealer says, that's fine, I'll give you 10% on the car, the £25,000, but I can't discount the £1,000, you're going to have to pay that flat. That's a very different scenario, factually, because in those circumstances, you'd say there's absolutely no way that if the customers had to pay the full £1,000 delivery charge, that the cartellist should be able to get any part of the 10% discount on the rest of the bill. It's a very different scenario, as I understand it, from the scenario where somebody goes into the dealership and says, the price on the road for this car is £26,000. And the customer says, I want a 10% discount. And the dealer says, fine, I'll give you £2,600 off the on-the-road price. Then the question, as I understand it, is whether the cartellist can claim any part of the delivery charge has been discounted as a result of the price.
My lord, exactly. And we would say
Yeah.
that because that price has been derived by virtue of a negotiation which took place between the consumer and the retailer, divorced in time, place, persons, divorced in pretty much every way from what the cartellist did, as a matter of principle, they are not entitled to point to that and to point to the fact that the consumer got a favourable price on that car and say, aha, that means our liability is reduced. And that is a principle which is entirely independent of the factual question that we've been debating so far about whether, in fact, the overcharge is passed on. It is essentially a question of legal principle which is driven, as we see from Fulton, by an inquiry as to causation. And you say, what...
As I understand it, the argument is that in that circumstance, when you are investigating loss, there's no reason to ignore the fact that the way it was presented and negotiated, there has been a discount proportionately of the delivery charge, because it would be said that in the first example I gave you, the person would have paid £22,500 plus the delivery charge of £1,000. In the second scenario, because it's an on-the-road price, the person would have paid £26,000 less £2,600, which is £23,400, I think, mentally, and it's a different price.
It may be your lordship's quite right to have opened this exchange by saying, again, it's factually sensitive, because it may be that in order for the CAT to adjudicate the causation test, is there a causal link between what the cartellist did and what the consumer has now achieved in terms of a discount? It may be that they do need to have the opportunity to adjudicate that point at trial as well. But we say that there is an important argument of principle open to us here. And what we see from each of the cases, from Fulton, from Needler, which was the negligence case, and from Allianz, which is the FX trading case, is that an inquiry about but-for causation isn't enough. Because in each of those cases, but for the wrong, the consumer would have been, essentially, it would have had the benefit. So, but for the wrong in Fulton Shipping, the consumer would have sold their vessel later and at a lower price. So the but-for
Just
causation.
Arithmetically, in the world in which there was no cartel, the hypothesis, I think, is that the on-the-road price, subject to the wrinkle you mentioned earlier, the on-the-road price, the hypothesis is, would have been less than 26,000, because there would have been an element of overcharge. There's an element, the £26,000 on my hypothesis includes an element of overcharge arising out of the cartel. So the hypothesis is that if the cartel hadn't been in existence, the overall price would have been less. And in which case, if you get a 10% discount on the overall price, just arithmetically, you would be better off, I think, as the customer, wouldn't you?
I'm sorry, somebody's trying to hand me a note. I think what your Lordship is positing is a scenario where the actual presence of the overcharge makes a difference. Whereas, makes a difference to the way in which the parties negotiate. Whereas this...
No, the presence of the overcharge doesn't make any difference. It's just a customer who comes in and says, I just want 10% of the on-the-road price that you just quoted to me.
And the 10% is greater because of the presence of the overcharge. Is that... I'm sorry, my lord, I may not be understanding the point.
Well, because you start from a higher list price where there is a cartel. If you start from a lower list price because there's no cartel, you will, as a consumer, have suffered some loss, because even though you get a discount on the overall price, you still end up paying a little bit more because you start at a higher point.
My lord, yes.
And I think the point is that's just one transaction. There's no two transactions. That's just loss. There's just one loss. It's not a question of loss being caused by the cartelist, which is then mitigated in some way by the consumer negotiating a discount. It's just one loss.
My lord, yes, that's the point that's put against me, and it's one of the bases on which the tribunal dismissed this point. I do say that it is not determinative that there is simply one transaction, because one still has to apply the test in the case law, which is having identified a benefit, and the benefit is the consumer has benefited from a reduction in the price of their car. You still have to ask, is there a causal relationship between the cartelists having cartelised shipping prices and the fact that the consumer was able to get a discount?
Yeah, well, I think we've got that point.
My lord, I was planning to take your lordship through the case law, but it may be that we've aired it sufficiently by today's...
Well, it's up to you, but we do need to keep an eye on the time.
My lord, I'm conscious of that. I would simply emphasise then that if the court has time to look at the case law, what we will see is that but-for causation isn't enough. So it's not enough to say that but for the cartel, you wouldn't have gained your benefit.
Yeah.
You still have to ask what's the causation question. And in each case, so for example, the Allianz case is a very clear one in the sense that the presence of the cartel, it's maybe the equivalent of the point my Lord Snowden was just putting to me. The value of the funds in that case, the net asset value, was lower because of the effect of the cartel. That was the assumption that had to be made. And so when investors redeemed their investments in the funds, they redeemed them at a lower price because of the effects of the cartel. So there was very clear but-for causation, meaning that the funds essentially paid out to the investors at a lower rate than they otherwise would have done. And nevertheless, it was found that that's simply the occasion for the benefit. It wasn't the cause of the benefit. And so it wasn't taken into account.
Yeah, but there are two transactions there. One is the loss caused to the fund, and the other is the redemption by the...
My lord, that's absolutely right. It's true that there are two separate transactions. I do maintain the submission that that is not the answer to the inquiry. Simply to say there are two transactions doesn't tell you whether or not the benefit in this case, the better price for a car, is causally related or not. There's no inconsistency between the fact that we rely on that transaction to show that the price has been passed down via the delivery charge, because there is a causal link there. We say a very clear causal link between the conduct of the shipper at the top, cartelising, imposing a price, passed down the chain to the consumer. What is the causal link to the good price that the consumer negotiates with the retailer. That is not something that the shipper had anything to do with whatsoever. And in my submission as a matter of principle, based on these cases, it is not for the shipper to point to that and say, I can rely on that good price as reducing my liability.
Yeah.
My Lords, I'm going to move to deal briefly with K-Line's appeal. In our skeleton, we understood Mr. Singler's criticism to be that the factual assumptions which underpin the class representative methodology were, as he described them, highly prescriptive. We heard from Mr. Singler yesterday that actually that wasn't his criticism. In any event, it was a characterisation that was firmly rejected by the tribunal. That's at paragraph 103 of the judgment. Tab 11, page 171. We see there a summary of essentially the same point that's been made before this court, and the tribunal says at 110, we have scrutinised the proposed methodology, including the applicant's industry expert evidence in detail, and have addressed the specific challenges raised by MNW. Both the applicant's industry experts have a great deal of experience in the motor industry. Their evidence is clear that any overcharge would have been passed on and that NSCs would seek to maintain a minimum margin. We would not characterise those as extreme factual assumptions. In principle, they are flawed. So we see why that criticism is no longer maintained, because it was rightly dismissed by the tribunal. Mr. Singler accepted your Lordship's formulation of the points of law that he was seeking to advance yesterday. He accepted that there were two purported errors of law, the first being in deciding the question of feasibility of adapting the methodology, the tribunal reversed the burden of proof, and secondly, that it was an error of law for the CAT not to have considered how the methodology could be adapted in the event that the respondents won on some or all of the contested facts. In our submission, it's very clear that neither of those are made out. Starting at paragraph 93, which I've already shown the court, this is the one where the tribunal records Mr. Robertson has made clear that the methodology is necessarily provisional at this stage, and data disclosed or evidence adduced could have an effect on the analysis required to assess the overcharge. That, in my submission, is the tribunal's assessment based on what it is seen in the methodology, and so there is no burden of proof there. It has been persuaded by what it has seen, no reversal of the burden of proof. The criticised language is in paragraph 111 on page 173. And what they say is, at this stage, we also have no basis to conclude that it would not be feasible for any successful evidential challenge to the quantum of loss claimed to be addressed, whether by adjusting the methodology or by making some other adjustment to the quantum of the award of damages to arrive at a reasonable estimate of loss. And they go on to give a particular example. In my submission, the language there is not reversing the burden of proof. It's simply the sort of hypothetical language one expects to see, and which is necessary because, of course, the tribunal doesn't know what the evidence in due course might be. We are at, as we've emphasised repeatedly, the very early stages, and so it can't express itself in categorical terms because it simply doesn't know what evidence might in due course be adduced. But it has made an informed assessment, and it's satisfied that the methodology is sufficiently flexible to accommodate adjustments. And that, in my submission, is one of those assessments that it's appropriate to call a large margin of discretion. And I've already shown you paragraph 127, where the tribunal is expressly contemplating a potential adjustment in respect of negotiating away of delivery charges. So in our submission, there is very clearly no error of law in the tribunal's judgment as alleged by K-Line.
Yes.
My Lords, unless I can assist further, those are my submissions in response to the appeal.
Thank you very much, Ms. Hall.
May it please your Lordships, our basic point, as you've seen in this appeal, is that in order to be certified and in order for their claim not to be struck out, the class representative needs to plead and advance a methodology to prove that class members suffered a loss as a result of the cartel when they purchased their vehicle. That's really the fundamental point. and the class representative's case on loss is based only on the delivery charge and not on the purchase price of the car. Now that in a nutshell is what we say is really all you need to know to decide this appeal, because even now in the Court of Appeal, my learned friend is not alleging that the cartel affected the purchase price that class members paid for their cars. So on their case, if a class member paid £20,000 for their car during the relevant period and would have paid £20,000 for the same car had there been no cartel, that person has nonetheless suffered loss because of the cartel overcharge.
Aren't they entitled to say, well, we have this delivery charge, we've identified the delivery charge, we know it's inflated, we know it's been passed on in full to the consumer. That is a fact from which it is possible to infer that the overall price of the car was increased as a consequence of the cartel. Alternatively, it can be treated by the CAT as a proxy for the price of the car, absent other evidence.
My Lord, with respect, we say no, because that isn't the case they've pleaded. Now, this is not a technical pleading point. It goes to the fundamental basis for their claim. Now, in the course of the point that my Lord just put to me, you said we know that the delivery charge has been passed on to consumers.
Well, that's their case.
My Lord, yes, but it's an important point. It's not just a semantic point with respect, because I think, as you said yesterday, my Lord, that the competition law jargon of pass-on shouldn't be allowed to obscure what the question is here, which is loss. So let's, if we may, look at it in terms of loss. They are not advancing a case, and they have not advanced a case, that there is a link between delivery charges and the total purchase price of the car. So it would have been open to them when we made our point loudly and clearly. You've seen that in our response to the application for the CPO. When we made our point that their case is legally flawed because they haven't sought to address loss by reference to the prices paid by consumers, the only price consumers paid, which is the price of the car, that's what they're buying. They didn't amend their claim, even in the alternative. So they didn't say, well, we've got this case about siloing of the delivery charge, but in the alternative, if you're right that we need to look at car prices, we say there's a link between the two. Or they didn't say, well, we're referring to delivery charges, but only because that's a proxy for loss. If they had done that, that would have been a different case. And it's a case that Ms. Ford is even now disavowing, because she said repeatedly in response to the court's questions, no, that is not our case. We are not running a case based on the prices of cars. We say that's irrelevant. Now, so if they had run that case, it would have looked very different. So they would have had to have pleaded a link between the delivery charge and the price of the cars. And that link would have been open to scrutiny by us and by the tribunal at the certification stage. So perhaps I can put it like this. If we're right about our basic point that a consumer who has paid £20,000 for their car during the cartel period, but would have paid £20,000 for their car absent the cartel, has suffered no loss, there are really two courses open to the class representative if we're right on that. The first course is to say that we're wrong as a matter of law. That's Fulton shipping. Now, I'm not going to take up more time on Fulton shipping, because you do understand that I think the battle lines are drawn, and you understand our response to that, which is that it is one and the same transaction. Yeah. That the second string to their bow is that, well, let's say we're wrong on Fulton shipping. This is all a question of fact for later. And on that point, it is essential in our respectful submission to analyse what do they mean by all a question of fact for later. Because that's what they say, and that is what the tribunal found. And of course, we on this appeal are challenging what the tribunal found. We're saying that it was wrong as a matter of law. First of all, before I get to what they're not saying, it's not a question, and there was, I think, some debate between Lord Justice Green and my learned friend about talking about counterfactuals. And I think it ended up in the right place, if I may respectfully say so, in the sense that there's no question of choosing between two counterfactuals. because there is only one counterfactual in this case, and Ms Ford accepted that. The counterfactual, the purpose of a counterfactual analysis is to compare the position with the cartel and the position without the cartel, with the infringement and without the infringement. So the only counterfactual that we're looking at
shipping charges which have not been artificially inflated.
Exactly, my lord. So counterfactual in terms, if we're getting rid of competition jargon, that's one thing that we can put to one side. So then the question is, what are these facts that are supposedly going to come to the class representatives' aid to demonstrate that their case, based on the delivery charge, is sustainable? And this is really the critical part of this appeal in our respectful submission. And it's important to identify what are the facts they rely on and on which the tribunal relied, and what are not the facts that are being relied on. And let me deal with what the facts aren't, first of all. So the relevant facts that Ms Ford refers to are not facts which seek to establish a link between delivery charges, between the line item of the delivery charge and the total price paid by customers for their cars. Those are not the facts that she seeks to rely on. So that they're not seeking to rely on facts that go to questions like, how did manufacturers set their list prices? Or how did consumers negotiate on the total price? And what proportion of consumers did what type of negotiation? They're not seeking to establish that link because their case is very clearly that the prices of cars are irrelevant.
So to go back to one of Ms Ford's examples, if there's a cartel in bananas, that may or may not push the price of lunch up, but you're only looking at a banana.
My lord, there are all sorts of factual examples, and there may be other cases in which one is buying a product and the delivery of that product. There may be cases like that, but that is not this case. It's not. There's no case. There's no fact which is open to dispute, which affects that position. So it's a bit like my example. We are the same or analogous to my example about the wine. Or take buying an iPhone. So iPhones are delivered. Ireland are the distributors of iPhone in Europe. So when I go to Regent Street to buy an iPhone, to the Apple store, I'm buying an iPhone that's been delivered from Ireland, but I'm paying for an iPhone. It's a legal nonsense to say, well, there's a delivery charge that's been inflated, and even though the price I pay for my phone is exactly the same as it would have been absent that delivery charge, I've suffered loss. That's really the fundamental point here. And the facts on which Ms Ford relies and on which the tribunal found that this is all fact sensitive are not facts, let's be very clear about this, which purport to link the delivery charge. So they're not, going back to your question, my lord, they're not trying to demonstrate that the delivery charge is a proxy for the overall charge, because they have very clearly disavowed that case. They're not even running it as an alternative.
But it would be legally sustainable to run that case, would it?
Well, my lord,
To say
as a
that
matter...
because of limitations on available data, for instance, we've chosen a proxy, or the other way I suggested it might be put, that you can infer from this charge that the overall price was higher.
My lord, I think that then we could not run our strikeout argument. So we could not say that that was unarguable as a matter of law, because they would be aiming at the right loss. They would be seeking essentially our point would have been accepted. So they would be claiming loss, which they're not currently claiming. So my answer to your question is that we would not, I don't think, be able to run a strikeout argument, but we would be in a very different world, because had they run it in that way, then the methodology that the tribunal would have considered would have been a methodology which seeks to establish that link. Now, of course, what we say are these amounts are absolutely tiny, and when people are negotiating about very, very big sums, and they say, right, we want the car for £20,000 rather than £20,600, the £20,000 is unlikely to have changed, whether or not the £13 overcharge was included. And so, but these are all points that the tribunal could have grappled. That the tribunal could have grappled with on the CPO application.
I'm sorry, didn't they grapple? How do we construe the last half of 125? These are tribunal's finding, for purpose of certification only, that delivery charges are separate, increases in cost not absorbed, not wrapped up not considered as part of a single undifferentiated price are considered separate. I mean, those are their findings of fact. And Ms. Ford says, well, they are very separate. There is no connection with the overall price. So they're simply saying, I mean, you may say, well, she stands or falls on those, and if she fails on them, then you win. But aren't those provisional approval of findings of fact by the CAT?
My Lord, yes, but they're findings of fact. So these are, the finding there is based on the facts on which my learned friend does rely. So I've already said she doesn't rely on facts which seek to establish...
To link the two.
So, sorry?
Link. She doesn't rely on facts.
Doesn't rely on the link.
No.
So she's saying it's all about the siloing.
Yeah.
So what does she rely on in terms of the siloing? So she essentially relies, and we saw this yesterday in her reference to Section 3 of Goss and Whitehall, which of course forms the basis for Mr. Robinson's methodology. That's on which that's the section on which he founds his methodology. Let's turn that up, please. So it's back in the supplementary bundle, tab 6. From 244. These are essentially the facts that we're coming to now, on which both Ms. Ford relies and the tribunal relied in reaching its conclusion at para 125. They're not link facts, if I can put it that way. So what does this establish? This establishes, if we look at paras 3.5 to 3.7 on page 245, I'm just going to summarise it because you've seen it before. But it establishes, first of all, that the overcharge is reflected in the delivery charge made by OEMs to NSCs, and that delivery charge is itemised separately. It establishes that, and this is 3.8, that NSCs will then bear that cost, so they'll pay that amount to the OEM. Retailers, and we see this in the second, more clearly in the second Goss and Whitehall report, which I won't turn up now, it establishes that retailers then pay a delivery charge to the NSC, which includes the overcharge on shipping. And then if we turn over the page to 317, we see that this establishes that it's highly unlikely, Goss and Whitehall say, that OEMs and NSCs would not recover at a minimum their delivery costs in full, and of course that would include the cartel overcharge. And they say in parentheses, further down in that paragraph, that there's no need or incentive for retailers to absorb these costs or offer any discounting either. And then what you see, you then have to see what they mean by that. And at the retailer to consumer stage of the supply chain, the class representative relies on paragraph 3.16 that the delivery charges are often separately itemised on the sales literature and or on the customer invoice. And they also rely on paragraph 3.18 that that it's rare for a retailer to discount the delivery charge. In other words, while the price at which the retailer sells a car is separately negotiated or agreed with each class member, what Goss and Whitehall are saying here is that the final agreed price is very rarely expressed on the invoice as including a discount on the delivery item specifically. So that item specifically is not discounted. Now, we at this stage of proceedings, and for the purposes of my argument on this appeal, we do not dispute any of this. So we can take all of these facts as read, all of these facts on which Ms. Ford relies and on which the tribunal based its finding at paragraph 125. And our essential point on this appeal is that, assuming them all to be correct, they do not establish loss. So they cannot justify looking at the delivery charge in isolation.
So your point on para 125 of the CAT is there may be findings of fact, but they are irrelevant findings of fact.
Yes, exactly, because they don't grapple. The CAT has lost sight of the fact, or this is the error, has lost sight of the fact in 125 that money is fungible. And so that it doesn't matter if something is labelled as a delivery charge or not, because all the consumer is paying for is a car. That's what they're concerned about. Did they suffer loss because they paid more for their car? That's the only basis on which they'll be able to establish loss. And so the error that the tribunal has committed in paragraph 125 is to say, because of all of this stuff here that we've looked at, which we accept for these purposes, which is that the cost is carried through, that it's reflected in a line item in the invoice in some cases, and that that line item is not specifically negotiated. They say, all right, on that basis, we're accepting the silo argument. And the problem is that that doesn't meet our fundamental objection, which is that as a matter of law, that does not equate to loss. So that's where the tribunal's gone wrong at paragraph 125. Now, had the tribunal been saying something different, and in fact it's more fundamental, had the class representative pleaded something different, which is to say, coming back to my Lord's point, we recognise that we need to show, in order to establish loss, we actually need to show that people paid more for their cars than they would have done absent the infringement. But what we're going to look at is the delivery charge, because we think it's a reasonable proxy for X, Y, and Z reasons. Then that would have been a different case that the tribunal was analysing at the certification stage. Now, I just want to show you I want to show you a brochure just to illustrate our point. It's back in the supplementary bundle at tab 11.
Just before we do that, your point on the fungibility of monies, isn't that what they are? The CAT is addressing in the last two sentences of 125. They're not wrapped up. They're not considered as part of a single undifferentiated price. In other words, you've got two pots of fungible money, delivery fungibility and car fungibility. Isn't that what they are? Whether it's right or wrong is really irrelevant for the moment. I mean, there may be great force in your point, but one has to, I know this is rather a condensed paragraph, but I rather assume that this was their riposte to your point at 120 of the judgment, where they set out your essential point about fungibility, and they say it ain't fungible, at least at this stage.
My Lord, I think you have to read the last sentence in the context of what they're examining in terms of the facts that are said to be, that said that the class representative is said to rely on. And the facts are summarised in the first sentence, the first half of 125, and also in 126, and essentially it's first half of 125 and 126. And they're all the points that I've taken you to in Goss and Whitehall. There is nothing else. So they're not establishing a link or that delivery charges are a proxy. What they're saying is, well, it's treated, essentially it comes down to this, it's treated on the invoice as a separate line item and the cartel overcharge finds itself in that invoice. Well, we say, let's accept that. As a matter of law, it's nonsensical, we say, to say that if you stop at that point, you've demonstrated loss. And that's the error, that's the legal error. And so when I talk about fungibility of money, what we're saying is it can't depend, whether a consumer has suffered loss, can't depend on whether they say in the negotiation, well, I want the car to be 20,000, so please knock 6,900 off. Or whether they say, I want it to be, it can't be a different outcome if they say, well, I want the car at 20,000, but can you please knock some off the delivery charge?
But you're making that submission on the basis of one particular factual scenario. I mean, if a customer simply went into the showroom and said, I'm actually quite flush, just tell me what the list price is, and, oh, I see the delivery price, that's fine, I'll just pay the 100%.
Yes.
In those circumstances, if the rest of the methodology is correct, or the evidence that has been put forward by the claims is correct, that separately expressed delivery charge and paid, which is paid for 100%, just like the list price of the car, includes an element which is inflated due to the cartel, and the customer paying in those circumstances a price to be able to drive the car away, which he won't be allowed to do if he doesn't pay both the listed price of the car and the delivery charge, will have suffered a loss as a result of the cartel. Now, in that scenario, he will.
My Lord, I accept that.
But take the other extreme, the guy who walks into the showroom and says, it's an on-the-road price, it's just a single price. In those circumstances, why wouldn't he suffer a loss if, in fact, as part of the price, the single undifferentiated price he's presented with, the on-the-road price, there is an element which, unknown to him, the retailer and everybody further up the chain has described as a delivery charge and which includes an element of overcharge. He will have suffered some loss, won't he?
My lord, only if he's paid more than he would have paid in the counter.
Yeah, but this is a person who is flush and goes into the showroom and just pays whatever he's asked to
Yes.
pay. And, you know, on the face of it, if your clients hadn't overinflated their charges further up the chain, the element of that one price, which internally the dealer knows is described to him by the NSC as delivery charge, will have been overinflated.
My lord, I agree with that. So
Right.
I'm not saying...
So those scenarios, there will be loss, and there's loss. I mean, you've picked the one example where actually it's arguable that because of the way that the customer has approached the negotiation with the retailer, and the retailer has accepted it, it might be said actually he would have paid the same price come what may. Why isn't that a factual issue to go to trial, provided that the methodology is capable of accommodating those factual scenarios?
My lord, because both the pleaded case and the methodology are not capable of accommodating those factual scenarios. Because the methodology, starting with the pleaded case, my lord, the point that you've put to me assumes we're right on the point of law. So it assumes we're right that you have to look at car prices. And the question then is, what is the link, depending on the factual circumstances of the list price, how the list prices are set and how the negotiations transpire? What is the relationship between the list price, the delivery charge and whether or not, and the price paid by the consumer? So I think implicit in your question is you're assuming, as it were, in my favour, that you can only show loss if the consumer actually paid more for their car. But you're saying,
actually, I'm not sure I did make that assumption. Because the first example, in fact, it depends how you define the car. The consumer wouldn't have paid more for the car. He would have paid more for the delivery, which was part of the invoice, which he had to pay in order to be able to drive the car away. So I wasn't making assumptions. I was just presenting three factual scenarios. And
Right.
I thought your objection was actually that the methodology, which is designed to show commonality, doesn't cater for those three scenarios.
my lord, and we say that it doesn't, because the methodology has to be a plausible methodology that according to which at trial there is a realistic prospect of demonstrating loss and the extent of loss to the class. And
In each of those scenarios, given that the class is said to include, as I understand it, people who could fall into any one of those three scenarios.
my lord, yes. And so going back to the point I made in opening about list prices and about negotiation, so where you have this overcharge that's reflected, so let's accept everything they say, and let's only deal with the case for the time being, which is where the delivery line item is indicated on the invoice. So let's assume that, and let's assume everything they say is correct in their evidence. And so what you end up with is a delivery line item that includes the cartel overcharge. They say, well, that's all we need to show, that's loss. Now we say, no, that's not loss, because you only have loss if the person's actually paid more for their car than they would have done absent the cartel, because all they're buying is a car, they're not buying a delivery service. Most of these cars haven't been shipped at all, only 31% of them have been shipped. So they're not buying a shipping service, which is what the cartel was about. Now,
But in the scenario, I mean, the point is they're not allowed to drive the car away unless they pay all the items on the invoice. So you say they're not buying a delivery service. Well, that's true to some extent, but in a sense, they can't take the car without paying that part of the invoice.
no, my lord, that's right. Just as they couldn't take a car if it didn't have an engine or if it didn't have seat belts or whatever. So they're buying a car. So if you start from our fundamental point, which is they can't demonstrate loss unless actually they've paid more in the factual than they would have done in the counterfactual. And then you say, let's assume that this delivery line item contains the overcharge. Then one has to, then there are two things, really, two things that determine whether loss has been suffered. the two things are this. One is, how is the list price set, the on-the-road total price set? And the question there is the list price any different to what it would have been in the counterfactual? So, for example, if the overcharge is £14, is the list price now £14 higher? Or does the operation of competition in the market mean that it's not £14 higher? So that's item number one. Now, there's nothing about that in their pleading or in their evidence. So nothing in the methodology that asks anyone to look at that question. So that's point one. Point two is negotiation.
Yet. That's their point.
Well, I'm going to come to the yet. Can I deal first of all with the substance? But I'm going to come to the yet. So I've got that in mind. So the second point is negotiation. Let's assume, let's leave aside the list price point. Let's assume now, against myself, that in every case, and we don't have evidence on this, but in every case, the list price would have been higher because of the operation of the cartel, and higher by the precise amount of the overcharge, so not less, that there's full reflection. Then at that point, there is generally a negotiation, and we know from a passage in Messrs. Goss and Whitehorn's second report that my learned friend took you to yesterday, that in fact they've got 8 to 9% of the price of the car to play with in their negotiations. That's what Goss and Whitehorn say in their expert evidence. So there's then the possibility to negotiate, and that's accepted on both sides. There's no dispute of fact about that. Now, when the negotiation happens, my lord, you're quite right that there will be some cases in which the consumers, you may have cases where the consumer is not interested in negotiating at all because they're not very cost sensitive and they just don't negotiate and they don't, there's no discount and that's it. Then if the list price fully reflects the overcharge, they will have suffered loss. We accept that. We're not saying this is a case in which it's impossible to prove loss. But there will be other cases, and let me just demonstrate this by reference to something in the bundle so that you can see it. You can see exactly the point we make. If you turn up the supplementary bundle, tab 11, you've got here a brochure for the Mercedes SLK.
Give them page again.
Sorry, so that's supplementary bundle, tab 11, page 348. So let's say the court has that's a supplemental bundle.
Yeah, sorry, I'm just temporarily mislaid. 348.
Yes. And you should see just a one page. It says model prices SLK class.
Sorry, it's right at the back of my bundle. Sorry, that's why.
So let's say that a customer wants to buy the top. Let's take the top of the first model, the SLK 200 compressor. So you'll see the total on the road price in the final column at £28,525. And if you look at the footnote, that says that it includes a standard UK delivery charge of £500 including VAT. Do you see that in the footnote? So that will, on the class representatives case, which we're accepting for the purposes of this appeal, include a cartel overcharge. Now, the class representatives case is that the overcharge on Mercedes cars, and we see this elsewhere, it's going to be common ground, was somewhere between £1 and £15 depending on the year. So let's say the overcharge on this car was £15. Now, the class representatives case, as pleaded and as the methodology proceeds, is that because the £15 is reflected in the delivery charge of £500, the consumer has suffered loss. They describe it as pass on to the consumer, but really, as we've discussed, it's the same thing. The consumer has suffered loss. But if the consumer, looking at this figure of £28,525, negotiated to buy it for £28,000 and would have done exactly the same if the on-road price had instead been £28,510, i.e. £15 lower, then they have, as a matter of law, suffered no loss. That's really our fundamental point. Now,
I'm wondering if that's where does Broad Act's questions of computation come in? The CAT could stand back and say, hang on, there was a cartel, it pushed prices down. On this analysis, you get away stock-free. Another method of computation is simply to pro-rata that £15 against 500 and then just reduce the damages by that percentage point, which would be very small. Is that a completely illegitimate approach for the CAT to take as a matter of policy?
My lord, yes, we say it is.
So
Because
you get away with it?
It's not, no, we're not saying, so let me
You
just...
say somebody higher up the chain, mate.
It may be someone higher up the chain, or it may be this
But they've
class.
passed it on.
I'm so sorry?
They've passed it on.
Well, we don't know yet. We don't know that yet. We don't know whether they passed it on.
But if they haven't passed it on, then they've got that claim. That's their sum of money. If they have passed it on,
Yes.
you're saying it's an irrelevance and it can't be recovered.
No, we're not saying it's an irrelevance at all. So we are not saying that this is not a claim that can't be brought. We're not saying that at all. But we're saying something very fundamental, which is that if they are claiming loss, they need to plead a properly arguable claim for loss, and they need to put forward a methodology which is capable of establishing loss and the extent of loss. Now, if, and I come back to one of the points I made yesterday, if they were saying, let me first of all deal with data, because data...
When you say they've got to put forward a claim to plead loss, sorry to interrupt.
Of course.
This is all taking place in the context of a collective proceeding.
Yes.
I mean, I think it follows from what you said that within the class that they postulate, there will be people, almost as a matter of course, who actually have suffered loss. You know, because there probably are people who walk into the showroom and simply pay what they're asked, including an element of overcharge. But is your point that where you're trying to bring a collective proceeding, you've actually got to identify common issues which are addressed by the methodology? And that's, I thought, that's what your target is, that's what you're aiming. You're not saying there's nobody in their class who has suffered loss, therefore strike it out.
No, we're not saying...
You're saying there may be people in the class who suffered loss who, if they brought individual claims, you couldn't strike out. But they would actually have to say, well, I went in and just paid what I was asked. And look, there's a bit in there.
My lord...
But your point is you shouldn't be able to bring a collective proceeding unless you can demonstrate common issues which are addressed by the methodology. And then the question is, at what stage does the methodology have to address
My lord,
the common issues?
my point goes beyond that, I'm afraid. So,
Okay.
so let's take an individual consumer. So first of all, let me just clear out the suggestion that we're not saying, we haven't brought this, we didn't bring the strikeout application on the basis that it's implausible that the class, any member of the class has suffered loss. That isn't obviously the basis for our application. But then let's take an individual member of the class. Whether or not they've suffered loss will depend on the two things that I've said, both the list price, which may differ between manufacturers. And you can see why it may differ, because if you're somebody who produces all of your models overseas and has therefore a higher charge, you may be forced to mitigate that in terms of what you pass on to your list price. So even though you've said, and this is the fungibility of money, in the list price, this constitutes the delivery charge and it includes the overcharge, your actual list price may be no different than it is in the counterfactual without the cartel. So for the individual consumer, they would have to show, if I'm an individual consumer bringing a claim, I would have to show that the list price is higher than it would have been absent the cartel. And then I would also have to show that I haven't negotiated in the way that I've just demonstrated with the SLK. And so it's not right. So I think, my lord, what I'm saying, I'm answering no to your question, because it's not just because this is a collective action that this is flawed. It's really fundamentally flawed as a matter of law. And so the methodology point, I think, is peculiar to it being a collective action, because it's only in collective actions with aggregate awards that you have to show your methodology.
You go back to your main point. The customer doesn't suffer loss unless he paid more for the car in the real world than he would have done in the counterfactual world.
That is exactly my pure and simple point.
Yeah.
And
well, we understand that point.
my lord, yes, but the reason why it's not fact sensitive is because the facts on which my learned friend relies and on which the tribunal relied don't go to meet the point that my lord put to me, which is that the delivery charge is some kind of proxy for the loss. What they're seeking to establish is just because it's in the line item, therefore loss has been suffered, and we say
they're not
wrong.
trying to draw an inference from the delivery charge to the overall price, and they're not saying it's a proxy, either of which might have been legitimate as a matter of law, and therefore their claim is based on a false premise.
No, exactly. And my lord, can I just respond to a point that Lord Justice Green put to me about the broad acts? So let me take Merrick's as an example, which I happen to be acting on the other side for the class representative. And that claim requires consumers across the economy over a 16-year period who have bought goods and services in from any retailer that has accepted MasterCard to demonstrate that they've paid more for their products. Now, obviously, that can't be done on a consumer-by-consumer basis. You can't look at individual transactions. But it's been certified because the courts have accepted, and you'll know that you'll be familiar with the Supreme Court's ruling, but the courts have accepted that the broad acts can step in to assist class representatives in cases like this. And so what the broad acts means is, for example, that Mr. Merrick's doesn't have to go and get prices from Sainsbury's and prices from Texaco or Shell and prices, that doesn't have to do that. He can look, for example, to publicly available data demonstrating changes in prices and so on. But he had a methodology which aimed at the right thing, and he could point to publicly available data that was there. And so if this were a case in which the class representative was saying, well, we see your point, once we'd made the point loudly and clearly, we see your point that only a person that's paid more for their car suffered loss. We think that we don't want to go and get publicly available data about costs of cars, as Mr. Merrick's is doing. We want to show that the delivery charge is a proxy, and we're going to show it. We're going to show that it's a reasonable proxy on the basis of this evidence. And they had adduced evidence to show, for example, that that manufacturers, when setting their list prices, would inevitably have included the overcharge despite competition in the market, and that most consumers don't negotiate in the way I've just suggested to achieve a round number, and in fact a very high proportion do as Lord Justice Snowden suggested, which is simply say, well, I'm willing to pay the list price. If they'd done that, then that is something which, that would have been a different case. So the tribunal would then have scrutinised it. We could have adduced evidence, for example, to say, well, we don't accept that that's the right way of determining how many consumers do what, because we don't think that survey evidence is... And that's the kind of debate that we would have had. It would have been on the right footing. But what's gone wrong here is really a point of principle, which is a difference of view as to what in law they have to show. And I'm going to be repeating myself if I put the point again, but what we say is that fundamentally, in order to demonstrate loss, they have to show that consumers handed over more money than they would have done had it not been for the cartel.
Yeah.
Now,
right, got that.
My lord, I'm grateful. And just to respond to one of Miss Ford's points yesterday. So, in respect of the point I made about negotiation, she said, well, don't worry, because the discount that's negotiated comes off the retailer's margin, and none of it comes out of the delivery charge, because we've shown that delivery charge line items are rarely specifically negotiated away. But we say that's meaningless, because that doesn't affect the fundamental question of whether loss has been suffered.
Yeah.
Now,
I think we need to speed up a bit, because I think this part of the appeal really needs to finish by 1 o'clock.
I'm so sorry. Well, can I just deal with one last point, which is the timing point?
Yeah.
So the timing point is this, that we repeatedly, nobody is asking the class representative to anticipate points that anyone might make in the future. We're asking them to at least sketch out how they would deal with the particular specific point we set out in our CPO response. They had an opportunity to file a reply, which they did, and evidence, which they did, but none of it addresses this point of principle. And so it's simply not a question of a broad axe in the future or adjusting the methodology in the future. It's that this methodology does not meet our fundamental point and is incapable of doing so, because it simply does not look at car prices or anything like how people negotiated and how list prices were set. And so we say finally that if the gatekeeper role of the tribunal is to mean anything, then it must surely mean stopping claims going forward on the wrong basis. And so that's why we say that we should succeed on this appeal. And if you look at it in strikeout terms, we say the claim as pleaded does not plead a proper claim to establish loss. And so it should be struck out on that ground. And my lords, I won't take up any further time. I'm sorry to have taken us so close to 1 o'clock, but unless you have any questions.
Well, it's just that Mr. Singler needs to be able to say something.
My lord, I'll do my best. KK's appeal gives rise to two issues. The first is we submit a fundamental issue which goes to the collective regime more generally, and the second is a point specific to this case and this methodology. My lords, so far as the first issue is concerned, that's whether the process test requires the class representative to show that its methodology can take into account and adapt to points of which it is already on notice, points that the defendants are going to be making at trial, whether the process test requires that at the certification stage. And as your lordships know, we say it does require that, and the tribunal erred as a matter of law insofar as it held that the test does not require this. And I'll draw your lordships' attention in that regard to paragraphs 106 and 110 in particular. At 106, for example, ultimately, if the expert evidence can be successfully challenged at trial, the claim may fail, but the test is not so onerous that we should reject any methodology that may break down in the face of a challenge to evidence. That is not the threshold. And 110, we specifically reject the submission that points of difference means that between the witnesses means that the methodology cannot be satisfying the test. Now, of course, we all accept that certification is an early stage of the proceedings, but Ms. Ford's submission, and we do say there's been some flip-flopping in this regard, Ms. Ford started, and this was clear yesterday, she said in response to my Lord Justice Snowden, that where the class representative is on notice of certain points that the defendants will be running in due course, she said it is legitimate for the class representative to say, well, we see the point you make, but it's all a matter for trial. Now, I say there's been some flip-flopping because this morning she said she does accept that the methodology must be sufficiently flexible to accommodate different factual findings. But insofar as she is maintaining the first position, and that is indeed the basis on which the tribunal proceeded, we say that is misconceived. And I'd make 4 points in relation to this. The first is, if it is correct that they don't need to prove at this stage that they can adapt to points which the defendants have already made clear they will be running, then with respect, there is no difference whatsoever between the certification test and the summary judgment test. And we know that there is a distinction between the two tests. Indeed, this was argued about below, where the class representative said all they need to do is overcome the strikeout or summary judgment test. And we said, no, that's not correct. You've misread what the Supreme Court was saying in Merrick's. There are two separate bases on which a defendant can challenge. One is strikeout and summary judgment, and the other is process. And indeed, the tribunal accepted our submission in that regard. But if it is correct, as Ms. Ford was saying yesterday, that the class representative is entitled to put its blinkers on and ignore points that the defendants will be running at trial, then with respect, it is impossible to see how a defendant could ever submit successfully that a methodology or a case fails the process test, as long as it meets the rather different test, which is summary judgment. It would always be said, well, this is how we intend to run the case, and we'll see you at trial. And with respect, that would render the important gatekeeper role entirely OTO's. Now, the second point is actually to understand how would all of this work if indeed that position is correct. It's very easy to submit loosely, well, we'll deal with all of this at trial, but just to take a step back and think about how this case will move forward if it's right that they can put their blinkers on at the certification stage. We've already said what we'll be saying at trial, at least in part. Now, there are two possibilities. Either the class representative, we put our defence in, and the class representative decides to fold its arms and say, well, we'll go all the way to trial with our methodology as it currently exists. We'll keep the blinkers on, in other words, until we get to trial. Now, with respect, if that is the scenario, then the case will run into the sand, using Lord Sales and Lord Legate's language from Merrick's. And the job of the tribunal at the certification stage is to ensure that doesn't happen. So if that's what they intend to do, stick with this methodology, the case should be knocked out now.
Is this question for case management. I mean, can the CAC decide to have preliminary issues? We will decide on the facts what happens in the market, whether consumers do negotiate, don't negotiate. We won't take Mr. Goss and Mr. Whitehorn as gospel. You dispute it. Let's have a little trial about that. And once we've found the facts, then Mr. Robinson and whoever his counterpart is can go away and work out some quantum.
Well, with respect, my lord, in putting that as a scenario, one is jumping ahead. One is assuming they have met the certification threshold. And at this stage, the tribunal and the court needs to be satisfied that they have put together a methodology which will survive at trial. That's the test. So there may well be scope for preliminary issues and so on, but with respect, they don't arise unless and until they overcome this threshold.
Well, Microsoft talks about a methodology that works if the overcharge is proved, i.e.
Yes.
if they win.
At trial, my lord, it talks about the issues at trial. This is actually, I'm coming to this point. Can I just continue with the two scenarios? One scenario is you certify, and they say, well, we'll stick with the blinkers, and we'll run this methodology at trial. We say, well,
Isn't that actually to your advantage? If they stick with the blinkers and they have a all or nothing approach, and you then prove substantial negotiation so that it ain't 100%, don't you then just win?
No, I understand that point, my lord, but actually the way the certification threshold works, we say, and the authorities made clear, is that the court, that the reason there is an important gatekeeper role is not simply because of the defendant's interest. There is a wider public policy here. That's made clear in Merrick's. It's made clear in the Canadian case of Jensen at paragraph 10 of our skeleton. One has to have regard to public resources and whether this is going to turn out to be a grand waste of time. Because if that is the position, your lordship's right, we'll win at trial, but we say we should win now. And there really are two possibilities. One is they carry on, in which case we submit the case should be knocked out now. But the other is we plead a defence making essentially the same point now, which is you actually need to measure pass on and loss in the proper way. And then they adapt their methodology at that stage to start to grapple with the difficulties. But with respect, the court should not be certifying on the basis that they may well adapt in due course. All the court can do and should do is scrutinise the methodology they've put forward at this stage. And my lord, thirdly, we say as a matter of authority, the process test works in this way, which is that they need to show that it can adapt. And we do pick up the reference to issues at trial in the language of Rothstein, Justice Rothstein at 118. My Lord Justice Snowden picked up yesterday. It needs to be a methodology that's workable at trial for the court. It's not merely it works on the say-so of the class representative. Otherwise, that becomes entirely self-serving. And finally, we say also we do rely on paragraph 56 of Gutman, where Lord Justice Green talks about the methodology needing to work in the event that the defendant succeeds at trial. So, my lord, we say the first error of law is the tribunal saying they don't need to have a methodology that is shown to adapt. The second, and really this is where we've ended up because of Miss Ford's position now, she accepts they need to prove a methodology is capable of accommodating different factual findings. So the real question, the reason I said the second point relates to this case in particular, the real question is, have they successfully demonstrated at this certification stage that the methodology is capable of dealing with what we say are the different facts at trial? Now, at paragraph 111, we say there are two problems with the way in which the tribunal dealt with this point. First, they did reverse the burden of proof. We have no basis to conclude that it would not be feasible. It's a clear, in my submission, reversal of the burden of proof. Secondly, perhaps more fundamentally, we say they had no basis to conclude. So even if your lordships are against me on the reversal of burden of proof, we say there was an error of law here because they simply had no basis on which to reach that conclusion.
Is burden of proof the right phrase? We're talking about plausibility here, aren't we?
Well, the burden of proof in terms of satisfying the court that the process test is satisfied. They need to show that the process test is satisfied. And in saying no reason to conclude that it would not be adaptable, we submit that is a shift of the burden of proof. But the substantial or substantive point is actually that there was no basis to support that conclusion. And Ms. Ford, interestingly, this morning says, well, the language of this paragraph is understandably tentative because the tribunal doesn't actually know what adjustments or different methodologies might be used. And that's exactly our point. Because we've heard on multiple occasions, we've heard about paragraph 457 of Mr. Robinson's second report, which is the exclusion of the rental companies. And we submit that is a minor point in the grand scheme of things. It's just simply not grappling with the bigger and more fundamental point. He accepts at 414 and 433 and elsewhere, he hasn't begun to think about the other ways in which he would deal with this. And Lord Justice Snowden, rightly in our submission, points out that the common issue is not whether there was a pass-on, it's also and to what extent. And what they've done is they've said, well, we've assumed 100%, and then they've quantified damages. And we submit, actually, the debate has focused in this court very much on at the end of the chain. There were different negotiations and so on, and we say they don't begin to deal with any of those points. But we also submit more broadly, they don't deal with the points which arise at the earlier stage of the chain either. So what if, in fact, national sales companies weren't working in the way Messrs. Goss and Whitehall say? They have no methodology actually to measure what the loss was, what the extent of the pass-on was. And Mr. Robinson himself expressly says he hasn't considered how he would deal with those issues. And so we say the tribunal had no basis on which to reach that conclusion. And we do, with respect, just to pick up some final points, we say this is a fundamental problem for the class representative in this case. Unlike other cases, this is not a data issue. It's never been said that they can proceed in this way because of data difficulties. If one looks at paragraph 526 of Mr. Robinson's second report, it's a very narrow point about his ability to observe delivery charges. He is not saying, as is said in other cases, we need to do it in this way because of data issues, nor with respect to a question that Lord Justice Green has put on a number of times. It's not a question of aggregate damages. It's not a case of winnowing out certain people down the line who may or may not have suffered loss. This is a more fundamental point. It's not simply carving out those who suffered no loss. It's actually building the case up to establish what the loss to the class was. And that's why we say this is a highly unusual case. Refusing to certify this case would not undermine the efficacy of the regime, because what has happened here is highly unusual. In Gutmann, if the defendants were to succeed at trial, it was just a case of carving out some consumers. A closer analogy is the Merrick's case. Mr. Dimitri's explained some aspects of that case, but we rely on a slightly different aspect, which is if one looks, for example, in the Court of Appeal, where there's a summary of what the methodology is in Merrick's. In Merrick's, the claimants are not saying, well, we think it's 100% pass-on, consumers suffered all of the loss, and we'll see you at trial. The experts are actually saying, we are going to investigate the extent to which there was pass-on of the multilateral interchange fee down to consumers. And they intend to go about that through the use of different pass-on rates in different sectors. I think paragraph 21 of the Court of Appeal's decision summarises what the experts are intending to do. And we say that is where this case has gone wrong. They are not measuring the extent of loss. They are assuming loss, and the methodology falls over if we're successful on the facts. My Lords, unless I can assist any further, those are my submissions.
Thank you very much, Mr. Singleton. Right, well, we'll stop there, and this afternoon it's whether the states can be joined to this claim. Is that right?
In other words, the question of deceased persons, yes.
Yes. Right, 2 o'clock.